then I can get involved as well. Either as a defense side or either as the person that's trying to sue the other individual in order to enforce their rights. And yes, I do speak Spanish. So if anybody needs that service, I can do that as well. I have 22 years, or did have 22 years in the Oregon Army National Guard with 2 deployments to Afghanistan. Those were combat deployments, and then one Kosovo just a couple years ago to 1 deployment to Kosovo. So that was interesting. Formally retired now. So now I get to practice my trade day in and day out. All right, moving on to the first topics. So one of the things that I wanted to make sure and cover right off the bat are not just laws that are currently in place from previous year, but actually some laws that the Oregon legislature passed this past legislative session that are becoming enforced either this year or that will be enforced in the coming years. And one of them that you can actually see here is the first one that we're going to cover called the Crown Act. And what this piece of legislation is something that has been going and developing from state to state. There are several states that have actually developed this law, and Oregon is one of the, I guess you could call trailblazers with respect to this one. And what it says is pretty much that it prohibits employers from discriminating against individuals based on physical characteristics that are historically associated with the race of that individual. And one of the main ones that come to mind is a person's hairstyle. One example could be dreadlocks. African-American individuals sometimes tend to have longer dreadlocks or something of the like, specific hairstyles. And what this law does is that it prohibits employers from considering hiring an employee, from firing an employee, or for making employment decisions based on the employee's hairstyle or other physical characteristics. Some of them might be from Pacific Islanders that tend to have some ethnic tattoos that are sometimes on their body. Well, that could also be taken into consideration with respect to that. There's also some religion implications that apply to it, but here we're talking about it as it applies to a physical characteristic. So that's the first one. The second one is that an employer can no longer require an employee to have a driver's license as a condition of employment. So you cannot have an employee or have it in your application that it's a requirement for an employee to have a driver's license in order for them to work with you. The only exception to that is when the job requires that the employee drive. In those instances, because it's a necessity for the employee to drive, then having a driver's license is an essential piece of that. And if they don't have a valid driver's license, then obviously they would not be able to do the essential job function, which is to drive, thus they wouldn't be employable. So if their job does not involve driving, then you could not ask for their driver's license as a condition of being offered employment or continued employment. The third one is non-competition agreements. This is a stickler for some individuals, some companies that want to have everybody under their payroll sign non-competition agreements because they are afraid that the employee might go off and start their own company and compete against them, or go off and work for another employer and use the information that they have learned while working for the current employer against them as a form of competing. Well, the Oregon legislature has started, or actually has for quite a while, several years now, started to increase the ratchet to make non-competition agreements harder to enforce. So it used to be that you could have a non-competition agreement be enforced if an employee made around $80,000 a year, and as long as you made that non-competition agreement up to 2 years, that could be enforceable. But nowadays, you need several things to make those non-competition agreements enforceable. And one of the major changes to that the legislature did this year was to increase the minimum salary that an employee can make in order to make non-competitions enforceable as against that employee up to $100,000 and change. So now, if you have an employee and they don't make at the very least that amount of money in salary-wise, they have to be salaried employees, then you can't enforce a non-competition agreement against them. And then second, um, you would not be able to enforce the non-competition agreement beyond 12 months. So it used to be 24 months. It got reduced down to 18 months. And now it got even further reduced down to 12 months. So slowly but surely, they're making those non-competition agreements less likely to be enforced, or at the very least, harder for them to be enforced. That's not to say that an employer or a company doesn't have other options or other avenues that they can use in order to protect the trade secret, for instance, and maybe confidential information. And those will be things like um, a non-solicitation agreement or a confidentiality of information agreement that would prevent an employee from using confidential information of the company, or from going off and potentially using confidential information, which could include a client list, to go out and use that information to solicit business for themselves. And then finally, some of you might know that Oregon will be one of the states that will have mandatory paid family medical leave. So one of the trailblazers again. Oregon seems to be one of those states that wants to be a trailblazers in a lot of different things, along with California and Washington. The way that this is going to work is that it'll be a form of insurance that will be managed and sponsored through the state. So an employee would submit an application to the state saying, hey, I'm going to take family leave off, and I need for this to be paid. So it wouldn't necessarily come from the employer, it would come from the state. But what the employer would be required to do is to pay into the Oregon Family Medical Leave Insurance Plan up to a certain amount, which would be about 40% of what an employee makes, 1%. So it would be 1% of the salary of what an employee makes, but the employer would only be required to pay 40% of that 1%. So it doesn't seem like a lot, but when you have, 100 employees, when you have 50 employees, and they're all making, 50,000 or more, then that 1% times all of the employees that you have, then that can potentially increase to being a significant amount of money, increasing by the number of employees that you have, obviously. So if you have less employees, then not as much. All right. Moving on to the second one is paid breaks and meal, or let me put it this way, meal breaks and regular breaks. So I bring this up because it seems like it should be a very common thing for employers to know, is that, yeah, if you have employees, they should be given breaks. And also they should be giving meal breaks in order to consume a meal. But you would be surprised at the number of clients that I get that say that they don't provide their employees with breaks or meal breaks. And I wanted to reiterate that it's not whether the employer or the company has the privilege or the authority or the ability to actually deny employees their breaks or their meal breaks. In fact, you don't. Those are mandated by the state. Employees are required to get breaks as well as meal breaks. And if you don't, there's potential penalties for that, for either not providing breaks or either not providing meal breaks. Another thing that sometimes employers will allow employees to do is to allow employees to consolidate their breaks into their meal breaks to make them longer, or consolidate their breaks towards the end of the day to allow them to leave early, or at the beginning of the day to allow them to arrive later. It's all good and dandy, but it's not correct. It's actually not allowed under statute and Oregon regulations. If an employee works the majority of 4 hours, which would be 2 hours and 1 minute, they have to get a break at the middle of that time break of those 4 hours. If they work 6 hours or more, then they're required to be provided at the very minimum a 30-minute meal break. You can give them a longer meal break, but the very minimum is 30 minutes. For regular breaks, the minimum is 10 minutes and it has to be paid. You can give them a longer break if you want to. Sometimes employers will give them up to 15 minutes, but it will still have to be paid. The only thing that would not have to be paid is anything over 30 minutes. And then if an employee works a regular schedule hour of 8 hours, then they would be given a second break after their meal period, which is common. Most people know this, that if an employee works 8 hours, they get a break in the morning, then a lunch break, and then a break in the afternoon. And that's standard. So now you know, they have to be given their breaks. They are not allowed to consolidate their breaks into a longer meal period, and they can't consolidate their breaks to either come in early or leave early. I'll put it this way, to come in later or leave early for their work schedule. Okay, next one that I want to be able to cover is wage and hour, salary versus hourly. This is a tough one sometimes for employers to get, and something that I get to see regularly. The first one is that employers will look at an employee and say, you know what, I'm going to pay you on a salary basis, say $400 a week, or maybe $500 a week, or $1,000 a week. And we'll say that regardless of the amount of hours that you work, that's how much you're going to get paid. A salary basis. The thing is that not every employee is allowed to be paid on a salary basis. There's actually only a certain number of people or classification of people that can be paid on a salary basis. And by and large, those are the type of employees that can be considered as executive employees, administrative employees, professional employees, outside sales employees, and computer professional employees. So let's go over each one of those a little bit, just so that we are kind of clear as to what they are, at least as clear as mud can be, because sometimes this can be complex. So an executive employee is an employee that is upper management, C-level suite employees, the executive of the company, the chief operating officer, the chief finance officer, the CFO, the people like that, executive employees. Then the next one is administrative individuals. So this does not include administrative individuals in terms of like your front desk receptionist or support staff. Administrative individuals are those individuals that usually head off a particular department, such as your head of human resources. If you have a large enough company and you have a person that's solely dedicated to doing human resources, that would be one of those type of individuals. Second one is if you have an individual that manages, let's say, the company's finances. Well, that could potentially be also an administrative people because they manage individuals, as well as a particular department, like not just one individual that they manage, but actually an actual department with two or more individuals. The next one is a professional individual. And what this is an individual that is a learned professional. Think of it as an attorney. I would be considered a learned professional. A doctor would also be considered a learned professional. A CPA, tax preparer individual, certified public accountant. There we go. That's the right term. Those would also be considered learned professions because they take more than just, going to high school to get those type of degrees. It has to be something that actually sets out the individual apart from somebody that just goes to school and gets a regular degree. It has to be a degree that is focused on a particular field. Outside salespeople is just not for any individual that does sales outside of employment, outside of the work office. It has to be individuals that do primarily sales outside of the office, like they travel outside to make the sales. Think of it like, a door-to-door salesman, or something that goes, someone that goes to your client's business site to make sales. but they're actively outside of the company premises making those sales. Second one is a computer, or the last one is a computer professional. So this one is kind of what the name implies, is somebody that has a degree or substantial knowledge in computers, somebody that does IT, so intellectual or internet technology type work. Those type of individuals, because they have a specialized expertise dealing with computers, they also would fall under the type of individuals that could be paid on a salary basis. The next one is not just anybody or not just any salary will do. So you can't just say, I'm just going to pay you $300 a week or $400 a week or $500 a week. The minimum salary that an employee can make is $684 per week. So if you have an outside salesperson, a computer professional, an administrative professional, but they don't make at the very minimum $684 per week, then they don't qualify as a salaried employee and would have to be paid on an hourly basis. So a salary is paid regardless of the number of hours that an employee works. So if an employee comes in and they are properly classified as a salaried employee, but they only work 6 hours one day, well, they still have to get paid their entire salary amount. You cannot deduct 2 hours from that employee's salary. Similarly, if an employee, let's say, is sick and you have a sick time policy and they're off for 2 days during the week, they would still be required to pay the full weekly amount of $684 at the very minimum, or whatever the regular salary is, because their salary amount is not based on the number of hours that they work during the week. But on the other side, if an employee works 10 hours during a day, or let's say 50 hours during the week, then they wouldn't be paid overtime because, again, their time work doesn't depend on the number of hours that they actually work during the day or during the week. Thus, the amount of money that they get paid during the week also doesn't depend on whether they work overtime or not. Their salary is fixed. So if they work less than 40 hours or whether they work over 40 hours, their salary is the same. That's not the same, of course, with salaried, regularly hourly paid employees. If they work over 40 hours in a work week, generally they get paid overtime. So that's one big thing to consider here. One of the things that I want to mention also about hourly employees is this. So some employers, not knowing, most of the time is because they don't know, will say, you know what? Well, your work period is every 2 weeks. So let's say on week 1 you work 50 hours. But in the next week, the employee only works 30 hours. So you might say, you know what? Why don't we transfer the extra 10 hours from the previous week to the current week, to the second week? So then it evens out. Now you work, we'll say that you worked 40 hours one week, and then we'll say that you worked the next hour 40 hours. So you'll get paid for the total of 50, 60, 70, 80 hours for the 2 weeks that you worked. But I'm not going to pay you overtime because we evened out the hours between the 2 weeks. Unfortunately, that's not how it works. If an employee works over 40 hours in 1 week, they have to be paid the overtime hours that they work that week, regardless if the employee works less than 40 hours the following week. It's not based on every 2 pay periods. It's not based on how many hours they worked a month. It's based on the number of hours that they worked during a particular work week. Also, another thing is that you can't comp time for hourly employees. And that's very similar to what I mentioned previously. But in this particular scenario is where an employer says, well, this week you're going to work 50 hours, but the following week, you can take vacation for those 10 hours. Um, and I just won't pay you overtime because the following week you're just not going to come in. So it'll be fine. There's no such thing as overtime then. But that's also not how it works. You can't um, make overtime disappear just by giving an employee vacation time the following week. One of the things that I wanted to point out here is at the bottom right-hand corner, I did put a note on there that says that an employer is overall responsible for keeping accurate records. So even though an employee would be required to provide their timesheets to you, as well as making sure that they take their breaks generally and their lunch periods, at the end of the day, the employer is the one that's responsible for making sure that the records, i.e. their timesheets, their payroll documents at the end of the week, like their pay stubs, are all accurate. You can, of course, work with the employee and put some responsibility on the employee to say, hey, you have to make sure that your documents, when you submit them, are accurate and correct. And if there's issues, bring them up so that we can correct them. But at the end of the day, the employer is overall responsible, which is very important to know, because if an employer does not pay wages accurately, including overtime, then there can be very potential hefty penalties towards the end. Let me give you one quick example. If you have an employee that is terminated by you, meaning you fired them, and this employee, or put it this way, the employer fails to pay this employee within 24 hours or 48 hours of when the employee was terminated, then there's already a penalty assessed to the employer for failing to pay their final wages at the end of their employment. If the employee then sends a written demand letter to the employer saying, hey, you haven't paid me my last paycheck, and then the employer doesn't pay the employee their final wages within 12 days after receiving that demand letter, then the employer is automatically assessed a penalty of 30 days worth of wages to that employee. So I get this quite a bit. Let's say an employee works 1 week and you decide to terminate them, but they only worked a couple of hours during that pay period. So they're owed, let's say $50 for a couple of hours that they worked that week. But the employer forgot or refused to pay that employee even after they got their demand letter. So because the employer is now then assessed a 30-hour penalty, a 30-month penalty of wages, then that employee would not only be owed those $50 for the amount of hours that they worked, but also 30 days worth of wages. So 8 hours times the employee's salary times 30. So if an employee makes $25 an hour, that could potentially be a lot of money. On top of that, the employee can also, if needed, to get an attorney to help him get that money that he is owed, those wages that he is owed. He can also collect the wages or the salary or the legal fees that the attorney charges the client to get his money. So now you have, let's say, that $50 amount that you owe this employee on top of the 30 days worth of salary that the employee now gets for failing to pay him his final wages after a formal demand letter. And then an attorney comes in, and now the attorney is saying, well, I helped this employee get his salary and I spent 20 hours getting him his wages. Well, now you owe that attorney his fees for 20 hours. So it's very important that when an employee is owed wages, that they get paid the accurate amount of wages. And when an employee sends you a demand letter saying you owe me wages, for you not to disregard those letters and actually try to figure out what's wrong, and if there is in fact money owed to the employee, to pay them as soon as possible. Because otherwise, a $50 owed wages can end up being thousands of dollars at the end of the day. Okay, moving on to independent contractors. So as in the construction industry, of course, comes into play quite often. The thing is that one of the things that I tend to see is that corporations, companies, and individuals will try to treat everybody as an independent contractor. They'll hire somebody, let's say Sean Smith, and they hire him to do a potential job for one of the projects that the company's working on. And they say, you know, Sean Smith, you're going to be working for me on this project, but I don't really want to hire you as an employee. So I want you to actually come on board for this project or maybe subsequent projects as an independent contractor. And you know, from the beginning, that sounds about right. Like, yeah, why not? He's like, it'll be, you save on not paying workers' compensation for that additional employee. You save on not paying unemployment insurance, as well as employment taxes to the state and to the federal government. So it's a win-win, right? The employee or independent contractor gets the money that they're owed or that they worked for, and on top of that, the contractor saves on all those expenses that they don't have to pay. Unfortunately, that's not how it works. You can't just assign an individual as an independent contractor just because you want to. There are certain things that you have to take into consideration as to whether an individual actually falls within the characterization of an independent contractor. Paying them with a 1099, it's not enough to show that they were independent contractors. An agreement between you and an individual is not enough either. So some of the things that you have to consider is, do I actually have a degree of control with this individual? If you hire an individual and you're directing them when they can come into work, when they can go on breaks and leaves, or meal periods, and when they can leave, then you are pretty much exerting too much control over that individual. And on balance, that individual could be considered an employee as opposed to an independent contractor. Another thing to consider is, well, does this individual suffer the benefit or potentially the loss of making a profit or not? If you pay the employee by the number of hours that they worked, well, they don't really suffer a benefit of making more money or the detriment of potentially losing money, because the project or the amount of money that they're making doesn't depend on the project. It actually just depends on the amount of hours that they're working. So they don't suffer from potentially losing money or from making more money either. So because they are guaranteed the salary or guaranteed those wages, on balance, it could be said that they fall more towards an employee in a characterization than they would an independent contractor. And also the permanency of the relationship. How long is that individual actually be on your payroll, on your records, is actually doing work for you? If it's just for a small project that's a week, maybe that's enough. But the longer that they're actually working for you on different projects, be a month, 2 months, 3 months, 4 months, even up to a year, I've seen them. Well, the longer that individual is actually working for you, then the longer that relationship could be considered to be an independent, an employee as opposed to an independent contractor. And then finally is, well, are they using their own trucks? Do they have their own company? Have they filed with the Oregon Secretary of State saying that they actually have a business, an LLC or a corporation? If they don't, if they haven't really spent any money on their own business, on their own tools, on their own equipment, on their own supplies, on their own formalities for actually starting a business, then that potentially leads on balance for them to be characterized as an employee as opposed to an independent contractor. And why does that matter? Why should you care whether an employee is ultimately characterized, or the other way, whether an independent contractor is ultimately characterized as an employee? Why should you care? Well, the thing comes in is that if the state, for whatever reason, or the state agencies become aware that you have an employee that you're treating as an independent contractor, then they can go after you. They will go after you for backowed insurance payments. They could go after you for backowed workers' compensation insurance payments that are owed, and they can go after you for employment taxes. And this could be pretty hefty. They can run for years going back. Um, I ran into a situation where an employer had to close their doors because they were assessed a penalty of $60,000 for failing to properly classify individuals as employees when they were treating them as independent contractors when they were not. All right. Let's talk about this one for a little bit. A word about workers' compensation, because I want to make sure that people are aware of this. So I mentioned before in the previous slide, we discussed independent contractors. And I mentioned that one of the issues that could potentially fall within that is workers' compensation. So in an effort for a company to say, you know, I'm going to hire you as an independent contractor or even as an employee, but I'm not going to pay workers' compensation insurance. Well, that's already a penalty, and you can see why, because if an employee gets hurt on the job, then they can go after the company for their injury. Well, what happens when you actually contract out work to a subcontractor? So you have your company and you got a contract with the property owner, and you say, well, I'm not going to do all of the work. I'm actually going to subcontract some of the work to another corporation or another entity, another business. Well, one of the things that you have to be mindful about is to get verification that that subcontractor that you actually hired to do some of the work actually has workers' compensation for their own employees or themselves. The reason why is because under Oregon law, Oregon regulation 656.029, it says that the person that actually contracts with the homeowner has the responsibility of making sure that everybody else, including subcontractors, have workers' compensations for their own employees. And as an end, if an employee of that subcontractor gets hurt and they don't have workers' compensation insurance, then that liability jumps up to the contractor that hired that subcontractor. So it's always a good idea that when you are hiring a subcontractor, regardless of whether they show you a business card that says that they're a corporation or that they are a limited liability company, and particularly if they say that they are a sole proprietorship, that they in fact provide you with verification that they do have active and valid workers' compensation, because you don't want to be on the hook of when there is an injury for the independent or subcontractor employees or the sole proprietor employee, when they have an injury, for them to actually file a claim for workers' compensation and then for that liability to go up to you. So always make sure that that is actually in place at all times. Okay, let's talk a little bit about handbooks. So handbooks are a great way for a company to actually ensure that they have policies in place for their employees. So some policies could include, for instance, your policy relating to breaks and meal periods. If you have something that's different from the minimum standard, let's say you give your employees 15-minute breaks, then that could go in there. If you give your employees 1 hour meal breaks, then that could also go in there so that you know what your policy is, as well as your employees know what your policy is. Another thing is because there are required policies that have to go into your handbook or that you are required to provide employees. One of them is the Oregon sick time law, which says that an employer has to provide employees with sick time, either paid or unpaid, depending on the size of the employer, at the rate of 1 hour for every 30 hours that they worked. So you can accumulate, or an employee can accumulate time so that they can use later to either go see a doctor for their own medical reasons or a loved one's reasons. And that time either can be paid or non-paid, as I mentioned earlier. But you have to have a policy that shows the employee what your actual policy is. Is it an accrual policy, 1 hour for every 30 hours worked, or whether that employee is actually front-loaded the amount of time, which is generally at the very minimum, 40 hours a year that they can use. Another policy that you are required to have on there is your anti-harassment policy, meaning that as an employer, you have to tell employees that the company does not allow and that is completely against being harassed, sexually harassed, or sexually assaulted in the workplace. And that it also provides the employee with a mechanism of how they are to report those instances of harassment, discrimination, retaliation to the employer. And if you don't have those policies in place, that can be a ding against you in case there was ever a potential claim against the company for such those instances. And the other one is the Oregon Family Medical Leave Act, which applies generally to employers that have 25 or more employees. But this one's usually the law that most people recognize, aside from the federal Family Medical Leave Act, that gives employees up to 12 weeks to take care of a serious medical condition. Usually for female employees that that are pregnant and are going to go and deliver their baby, they're usually given that amount of time. But it's not just to female employees. It's usually to any employee that suffers a serious medical condition, including hospitalization, for instance. So those type of policies need to go into the employee handbook, and they need to be provided to the employee in order for you to comply with the state mandated requirements. Additional things that could go into the employee handbook as well would be any vacation policies that you have, or any potential eligibilities for leave that you might have, like unpaid leave, for instance. Those could also go in there. See what else would be good to talk about this. Also, your employee handbook becomes Exhibit A in case your company was to ever get sued for employment policy violations. If you don't have an employment policy handbook in place, then a potential plaintiff's attorney can say, well, how was my client supposed to know that these were the policies that the company had in place if they were never actually provided with their policies and employee handbook? So having that in place is always a good idea. Not an absolute requirement, but it is a good idea that I always recommend. And then finally, one of the things that I would actually like to share with you is a specific instance before we get into questions of something that happened to it was going to be a potential client that I felt compelled to actually share with you guys. So this construction company, newer on the market, got a email and then several phone calls from a potential client saying, hey, I build houses. And as a house builder, I want to hire your construction company to do part of the work. And the construction company was like, yeah, send me over the details of the work contract so I can send you a proposal. So this online personality sent them a copy of what they thought was going to be the contract that would govern what they were going to do. The construction company here sent them a proposal saying it's going to be this much to do the work that you're asking me to do. And then the online personality, after several emails and phone calls as well, said, you know what? Well, I have my company out of state, in Miami, but I'm going to send you some money so you can actually start buying equipment and materials for this project. Well, lo and behold, a couple of weeks later, the online personality said, well, you know what? I sent you the money, but I'm having trouble actually getting my bank to release it. They're saying that you have to actually deposit a certain amount of money before the bank will actually release it as a form of security. Well, the client did do that. Well, not the client, but the potential client did do that. They actually did send deposited money somehow to the would-be client in order for their bank to release the money. Well, what did that mean? That mean that this potential client actually got swindled. They got taken advantage of because there's no reason for a contractor to deposit money to a potential client's bank account for that client to release money to then pay the contractor. It's not doesn't sound right, right? It doesn't sound right. Well, it was a phishing scam, and unfortunately, this potential client got got on the hook for thousands of dollars that they shouldn't have. So I leave you that as a cautionary tale. To if it seems too good to be true, it probably is. So always make sure that you read your contracts and that you verify who you're actually talking to. Other than that, I think we've reached near the end of our presentation, and I will take on any questions that anybody might have.